over wills and what are the four most common misconceptions about these wills? Well, here to talk with me about that is Allison Lee, an attorney for Free Will. Allison, welcome.
Hello, Bob. Thank you for having me.
Oh, it's a pleasure, and it will be a pleasure to have you, first of all, describe what the heck a pour over will is.
Absolutely, Bob. When written alongside a trust, a pour-over will ensures that unallocated assets are, in the end, accounted for. Assets that haven't been transferred to the trust during your lifetime or transferred or poured over into your trust after first going through probate.
So, you wrote an article for Retirement Daily where you described the four most common misconceptions. Do you want to give us sort of an overview of those four items?
Sure, Bob, I'd love to. So, the first misconception is that pour over wills are unnecessary for those who already have a rev trust or revocable living trust set up. And yes, it's common to assume that pour over wills are unnecessary for people with revocable living trusts. However, very few people constantly update their trust, and they tend to pass away before finalizing the transfer of assets to their trust. So, pour over wills address this challenge in a straightforward way.
Right, so it's like a backup to the backup plan.
It's a backup to the backup plan. That's a great way of putting it. That's right.
Yeah. So you mentioned that these revocable living trusts should be updated. How frequently do you recommend that?
That's a very good question. So I would say, and many estate planning professionals agree, review your plan every 3 to 5 years or whenever you have a major life change. You get married, you have kids, you buy a major piece of property. But actually, when you have a trust-based plan, you also want to consider the implications of your plan every time you acquire new assets. You got to think about whether you want to transfer this asset or separately account for it in your trust.
Right. And then one other follow-up question is, in terms of those who need a revocable living trust, is it, and obviously when people think about estate planning, they think wills for sure, but they then may not be thinking about revocable living trusts. Is that something that everyone needs?
So I wouldn't say everybody needs a revocable living trust, but there's some aspects of a plan that make a revocable living trust desirable. First of all, if you have property out of state, so you live in Maryland, but you have property in Virginia, you live in Florida, you have property in Texas. So by putting the out-of-state property in a revocable living trust, you avoid a second probate or an ancillary probate, and that can save your loved ones a lot of headache and also the expense that goes along with that second probate. Another thing would be privacy. Wills are a matter of the public record. If you have something in your will or you have a disposition that you'd prefer to keep out of the public view, a revocable living trust can be a great tool to have in your toolkit.
All right, so that's misconception one. Number two?
That's right. Okay, number two, it doesn't really matter who the personal representative of my estate is because I plan to fully fund my revocable living trust. Well, yes, you might plan to fully fund your revocable living trust, but life can lead to the best plans not being completely executed. So it is important to think about who the personal representative of your will be because they might have an important job of overseeing your probate estate, including the transfer of assets in your probate estate into the revocable living trust. Separately, the personal representative might have other certain aspects. They might be a digital personal representative, and you really want to not overlook that position. Choosing the right person for the job is still important.
Yeah. So just definitionally, what does fully funding a revocable trust mean?
Yes, indeed. So that is to ensure that all assets that can be transferred into your revocable living trust are transferred. There are certain assets like a individual retirement account, an IRA, 401k, life insurance. You don't transfer those assets into your trust. Those are non-probate assets. They transfer by their beneficiary designation. So we're thinking of a piece of real estate, your tangible personal property, your stocks and brokerage account. You want to make sure all of those assets are transferred to your revocable living trust.
Right. So I think in a way we touched on misconception number three, but maybe you could do a deeper dive on that.
Yeah, that's a great point. So misconception number three, if I have a living trust pour over will, I have this, great plan in place, I don't need to make periodic updates to the plan. And we talked about what a pour over will is. It's it's the backup to the backup, as you said. but it doesn't mean you don't need to review your plan, periodically. I had said every 3 to 5 years or whenever there's a major life change. It's great to have this pour over will, pour over assets into your trust, but if your trust is out of date, if it doesn't reflect the beneficiaries that you want it to reflect, if it doesn't name the fiduciaries that you want to entrust your estate with, then it's all for naught.
Yeah. And we don't want that to happen.
No, we don't. And I'd say it's so simple. It's I know life gets busy. I have a 6-year-old, and God help me if I have time to breathe before I run off to his next activity. But you're sitting around on a Saturday or Sunday. You have a couple minutes. Pull out your will, pull out your rev trust, take a red pen, or a copy of it, maybe not the original. Don't mess up the original. But take a copy of it and start marking up. I don't necessarily want my sister to serve in this role anymore. My child has attained the age of majority. I want them to take on a more responsibility. Maybe you don't need the kind of trust that you had set up for minor children. Think about take those moments to think about how life has changed, and use that time to think of what you want to do, and then when you have another moment, you can see your attorney, or you can find a way to make those updates to your plan.
Yeah. Misconception number 4.
All right, here we go. There's no need to address what to do in the event the living trust isn't in existence. So this is this is not something you will expect to happen, but it's a possibility that the transfer of that the disposition of assets into your trust could be invalid or inoperative. Maybe there was a technical issue and the trust no longer is in existence. Not something we expect to happen, but things happen. It's good to put in the pour over will, rather, not just that you transfer your assets to your trust, but also that if the transfer to trust is invalid, that you want the same beneficiaries as we'd say as presently provided in the trust agreement. Essentially, you want the same disposition as if the transfer to the trust were valid. That maybe that's the backup to the backup to the backup, or something like that.
Plan B, Plan C. Okay, I got it. So we love to offer what I describe as actionable advice to people. Do you have any advice for those who are considering a pour over will, do's and don'ts, things to avoid, things that they must do?
Well, first of all, I'd say now that you know the misconceptions, a little bit more wiser. If the concept of the revocable living trust resonates with our user, and you're thinking whether it's the ancillary probate avoidance or the keeping your plan out of the limelight or out of the public records, if that resonates with you, I would say a pour over will into a revocable living trust is a great type, is a great plan design for you. And in that case, it's a good time to start thinking about who will be the trustee of your trust, what you want the trust to say, and also not to forget about the pour over will. It's not just, don't forget about that piece of the puzzle. It really is important to think about the pour over will alongside the revocable living trust to ensure that the plan design you have in place is something that's going to reflect your wishes.
All right. I know we've covered a lot of ground. Anything we missed or anything that just bears reemphasizing?
Again, review the plan 3 to 5 years or whenever there's a major life plan. I can't say that enough. I used to be in private practice, and we may see, a client come in and say, when's the last time you looked at your document? They say 10 years, 20 years. Don't let that happen to you. Take that red pen, take those, try to do it 3 to 5 years. And certainly when there's a major life event, your estate plan is really an important vehicle to ensure that your wishes, your desires are effectuated. And so I'd say make sure you do that review.
Yeah. So Allison, you've written a number of articles for us at Retirement Daily. We so enjoy you sharing your knowledge and wisdom with our readers, and now that we've done this video with our viewers as well, and we hope that you'll continue to do more of these with us.
Thanks so much, Bob. It feels like the community is family. I'd love to come back, and thank you for having me again.